Case number 108218, State of Kansas v. Kevin L. Brown Jr.
Good morning, may it please the court. Michael Whalen on behalf of the appellant Kevin Brown, and with the Chief Justice's permission, I would ask to reserve 5 minutes for rebuttal.
5 minutes is granted.
KSA 22-2905, proceedings after the preliminary examination, subsection 1. When a defendant is bound over to a district court for trial, the prosecuting attorney shall file an information in the office of the clerk of the district court charging the crime for which the defendant was bound over. In this case, Mr. Brown was bound over on felony murder and burglary. The burglary was premised upon aggravated battery, aggravated assault, first-degree murder. The aggravated assault upon which he was bound over, the finding by the court at the preliminary hearing was an aggravated assault against Ms. Green, not against Mr. Bolden, the ultimate victim in the case.
So that would be an error with respect to the preliminary hearing. Why isn't that resolved when you go to trial and have your trial?
It's not an error of the preliminary hearing, Your Honor. The judge at the preliminary hearing made appropriate findings that there was evidence, preponderance of the evidence to support an aggravated burglary premised upon an aggravated assault against Ms. Green. The state chose...
And there was evidence presented to support that.
Yes, Your Honor.
And the preliminary hearing is to determine whether there's probable cause to believe that a felony has been committed and that this particular defendant committed it.
Yes, Your Honor.
And so there was an ag assault, and there was a burglary, and there was a felony murder evidence to show probable cause. Why does the state have to prove, or the district court have to give explicit findings with regard to the victims?
I'm not saying the court has to make explicit findings. I'm saying that the state elected at the preliminary hearing and specifically stated on the record to the court that the only aggravated assault was against Ms. Green. Therefore, the state elected what would be the underlying or the companion felony to the aggravated burglary, and the aggravated burglary was the inherently dangerous felony relied upon for the felony murder charge.
But all of the evidence was presented at preliminary hearing that would support an ag assault against Mr. Green, was it not?
Against Ms. Green, not Mr. Bolden.
Mr. Bolden.
No, that was the state specifically stated there was no evidence of an aggravated assault against Mr. Bolden. And the distinguishment in that is at the preliminary hearing, the aggravated assault against Mr. Bolden at trial was premised upon the testimony of Detective Chisholm, who stated in his interview with Mr. Brown, he had said, "I was going over to the apartment to scare Mr. Bolden." And the state, in closing argument, relied on that to say he even admitted he was going over there. That testimony was not presented at the preliminary hearing. There was no testimony about any intent of an aggravated assault against the victim, Mr. Bolden, at the preliminary hearing. Now, this is significant because when a defendant says, "Hey, I need a bill of particulars," or "I think the complaint is deficient," or whatever, they're directed to, did they have notice of the charge, the sufficiency of the charging document? If they were apprised at the preliminary hearing of the evidence to be used against them later at trial, then the charging document is their notice of the crimes against them is satisfied. In other words, the defendant relies upon the evidence presented, and I would say the representations of the state within their discretion as to what charges they are going to pursue and how. And the finding of a preponderance of the evidence of the existence only of an aggravated assault against Ms. Green preempts the state from charging aggravated assault against Mr. Bolden, because the burglary was premised upon that ag assault against Green. He was not bound over. There was no finding of a burglary based on any actions against Mr. Bolden. He was bound over on a finding of burglary and first-degree murder premised upon an aggravated assault against Ms. Green.
Here's where I'm stuck. What difference does it make? I mean, if Bolden was killed in the process of this inherently dangerous felony, does it matter that he wasn't the original intended victim of the felony?
Absolutely.
Does he have to be the same? Does it have to be the same victim?
Yes. Jurisdictionally. Because the state has required before a person can be bound over, there must be a finding of preponderance of the evidence that the crimes have occurred. The state in this case chose what evidence they requested the court to use to bind Mr. Brown over.
And they chose a felony committed against Green rather than a felony committed against
Yes,
Mr.
Your Honor.
Bolden.
So there was no underlying evidence or finding by the preliminary hearing court that would support an aggravated assault against Bolden. The state chose. They had the
But
evidence.
the underlying felony for Bolden is the burglary.
Correct, which is premised upon the element of as
And they
the
showed
state as the state chose. Well, Your Honor, he was bound over on 3 different theories underlying his intent for committing the aggravated burglary.
Right.
The state chose aggravated assault and singled it out as their basis.
I understand. Assault
The
against
only
Green.
burglary.
Assault
that-
against Green, underlying the burglary, right?
No. Assault against Bolden. That's where the problem is.
That was the proof of trial, you said.
Yes, Your Honor.
Not at preliminary. At preliminary, the state was saying we are premising the ag burglary on the ag assault against Green.
The
Right?
state specifically said the only aggravated assault is against Green.
Okay.
Yes.
All right. It's the only aggravated assault that's troubling you on a notice kind of argument.
The notice and jurisdiction of the complaint in the charging document, and the fact that an individual can only be bound over based upon what was found by the court at the preliminary hearing.
How do you square that with the case law that allows amendments of complaints to conform to the evidence?
Well, that's kind of my later issue, Your Honor, in that if the state wanted to amend, they could have. They did not.
But,
And
but
in
from a
none of-
jurisdictional basis, is that necessary? I mean, if they can do it later, does that tell us that once you get past that preliminary hearing stage, you have jurisdiction over any offenses that are where there's evidence to establish it? Otherwise, how could we allow amendments post preliminary hearing?
If the state had made a request to amend, I wouldn't be making this argument.
How does that make a difference on a jurisdiction argument?
Because the complaint is the jurisdictional instrument, and the state changes the jurisdictional instrument to fit the evidence so that the jurisdictional instrument is in compliance with the evidence presented at trial. They have the courts are to be liberal by statute up until time of verdict. A complaint can be amended. The state did not amend their complaint here, and every count after the preliminary hearing was charged as 3 separate alternatives as the underlying basis for the felony murder was murder, aggravated battery, or burglary. The state chose burglary.
But those alternatives were never pled. Is that
No, the
never stated
alternatives
in the
were pled. The state chose which ones they would argue and how the instructions would go to the jury without ever amending the complaint.
which brings me back to my question, since those were there in the complaint, how does, I still don't understand how our case law doesn't work against you. Because,
Because only the state can make a request to amend the complaint. Court can't do it sua sponte, that's what Vaughn said. It's not the purpose or position of the court without a motion by the state, because it's the state's prosecutorial discretion as to how they're going to charge and how they're going to proceed to trial. But the state must ask permission of the court in order to amend, and it must be done then by a court's order allowing it. In this case, the state did not request to amend any of the counts that went to the jury, all of which were narrowed, and in particular on the aggravated assault issue here, there was no evidence that there was an aggravated assault against Mr. Green. So the preliminary hearing court could not have bound him over for any charges premised upon an aggravated assault against Mr. Bolden. They can't proceed that way because that's not what he was bound over for. And the complaint by statute must follow the order of the court for which he was bound over.
There was evidence presented at the preliminary hearing. Officer Hardy testified. There were 3 preliminaries all conducted together, correct?
Yes, Your Honor.
And then the prosecutor, at the conclusion of that hearing, said aggravated battery is when they went in the house and they committed the aggravated assaults, plural, or an aggravated battery or murder for that matter as the underlying felony when they entered that residence. And then when he's talking about the aggravated assault charge, he says, I believe that Ashley Green has established that, and I would ask the court to bind them over on that charge as well. So when he was talking about the burglary, he talked about multiple assaults, an aggravated battery, and murder for that matter. And there was evidence to back that up, so I can't understand how you say that the state elected a theory, and if you say that the court doesn't have to make detailed findings and make an election of which of those underlying when it binds over, then I don't know where we are here, where the error has come in.
Well, there was a clarification to the state as to the only aggravated assault. And they said the only aggravated assault was against Miss Green.
That's on the aggravated assault charge. But what you're saying is, you're talking about the aggravated burglary and the underlying felony. Isn't that your complaint? Not about the assault charge itself? Your complaint is about the aggravated burglary and what was used as the underlying felony. Is that what your complaint is?
Yes, Your Honor.
Well,
But what I'm saying is, the state elected and stated which aggravated assault that they believe the evidence supported.
well, they're not gonna prosecute for an aggravated assault against Mr. Bolden because they're prosecuting felony murder against him. And so they're saying the only aggravated assault charge we have is against Ms. Green. But there were these other underlying felonies that could support aggravated burglary. That's 2 different things.
I don't
You're
believe...
trying to say that we only have one aggravated assault charge that we're gonna prosecute, but the underlying, because you don't have to prosecute the underlying felonies for burglary. Would you agree?
Correct.
So I guess I'm not understanding where the complaint is. Because he was put on notice of all of the theories that would support burglary. The court bound him over. An information was filed. He was tried. Much of the same evidence that was at preliminary came in, and he was convicted. So I'm.
Well, my understanding, Your Honor, is what the state said was the only aggravated assault for which there was evidence was that against Ms. Green. Regardless of just saying there were other assaults and batteries, If that was the specific statement, and I don't have the quote here in front of me, I don't have the transcript directly in front of me, but my understanding, my memory of it was, that was the clarification statement by the state. The only evidence of an aggravated assault we have is against Ms. Green. Not, we are only charging aggravated assault against Ms. Green. And I think that's a huge distinction, Your Honor, because it's clarification of the prior statements. I do not at all disagree, and I'm not trying to argue that to support felony murder or burglary, that the other counts have to be charged, or the underlying felonies have to be charged or proved.
That's two different things. They may not have had evidence that aggravated assault was accomplished against Mr. Bolden. But for burglary, that makes no difference. It's what they intended to do when they entered.
And
Correct.
at the preliminary hearing, the intent, the only aggravated assault, see, I don't believe there's any showing at the preliminary hearing.
Rika testified that she heard Brown saying they were going over to Bolden's place to rough him up a little bit. Detective Hardy testified about his interview with Jalissa, and where the plan was to beat up Bolden. She said that.
Which would be intent to commit an aggravated battery or a battery, not an assault, Your Honor.
Yeah.
There wasn't an intention to place him in fear of imminent bodily harm. Neither one of those evidentiary statements support an aggravated assault. That's why the state said that the only evidence of an aggravated assault is against Ms. Green. Because the only intent of going over there to scare him was the testimony of Detective Chisholm, who testified at the preliminary hearing, but not to that information. That only came out at trial. And in closing argument, the state relied upon Detective Chisholm's testimony. He said he was going to go over there to scare them. There's your intent for aggravated assault. But that was not raised, nor presented, nor was Mr. Brown bound over for that assault.
Have any further questions of counsel? Would you like 30 seconds to wrap up? Or do you feel you've made your points?
I think I'm fine.
All right. Thank you, counsel.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'll also limit my remarks to issue 1 unless there are questions on the remaining issues. I want to break a little bit from how I had planned to start this argument because I want to pick up with something that was discussed quite a bit with opposing counsel. And I think Justice Johnson emphasized the point that I would like to stress to this court. We have to remember that there's a distinction between the aggravated assault against Green, which was charged as a separate crime in and of itself, as opposed to the aggravated assault that could form a basis for the underlying felony against, to support the felony murder and aggravated burglary charges. So first, I think just from a legal standpoint, it's important to not get distracted by the fact that yes, the only aggravated assault crime that was charged as a crime in and of itself was against Green. And as Your Honor pointed out, that's because against Bolden, it was charged as a felony murder. And second of all, we have to remember, as Your Honor also pointed out, that the aggravated assault, that the felony murder and aggravated burglary charges don't require proof that they actually did commit an aggravated assault against Bolden. They just require proof that the defendant went there with that intent. So I think, first of all, it's very important that we not get distracted by the aggravated assault charge listing Green as the victim. That we can almost, for these purposes, treat it as if it never existed because it really doesn't affect the analysis of this issue. So with that as a starting point, I think that really the defendant has raised 2 separate sub-issues within issue 1. One is a challenge to the sufficiency of the charging document, and then the other could be viewed as a challenge to the sufficiency of the preliminary hearing. With respect to the challenge to the charging document, this is this has to be analyzed under the post-Hall standard because it's something that is being raised for the first time on appeal. So because of that, we use common sense, we look at the complaint as a whole, and we construe it liberally in favor of its validity. Now, in his brief and today an argument, I haven't heard the defendant address Hall or try and specifically establish prejudice. And I think that has to be the starting point for this analysis. Second of all, I think that when you listen to the defendant's argument today, I heard him say that the state at some point during the preliminary hearing made an express affirmative statement indicating that the only aggravated assault was the one against Green. First of all, I would dispute, and I think counsel himself acknowledged as he was arguing to the court that he didn't have a specific record citation for this or that he couldn't find it in his brief. The record will speak for itself and it'll correct me if I'm wrong on this, but I think the reason counsel can't find a cite for that comment is because I don't think it existed. My notes and my recollection of the record do not reflect that the prosecutor ever said that the only aggravated assault to support a felony murder charge would be something that occurred against Miss Green. And as Justice Johnson pointed out, when you read the prosecutor's summation at the end of that preliminary hearing, he specifically references aggravated assaults, plural. Obviously, Green and Bolden were the only two people in that apartment. So when the prosecutor references multiple plural aggravated assaults as supporting the felony murder and aggravated burglary charges, not only do we not have an affirmative statement by the prosecutor that there was only one intended aggravated assault, but I think we have something specifically to the contrary. I'd also argue that there was evidence presented at the preliminary hearing that would support an aggravated assault charge against as an underlying felony. Specifically, Justice Johnson noted the fact that there was testimony presented at the prelim that the defendant before, and I think I have this cited on the bottom of page 12 and the top of the following page of my brief, that the defendant, before going to the victim's apartment, he made plans to get guns and then said that he was going to go rough up and beat up Mr. Bolden. So to suggest that there was no evidence presented or that the state never indicated that there...
How do you answer opposing counsel's response that that's an ag battery, not an ag assault?
I think that testimony certainly could also support an aggravated battery, but I would also submit, though, that would be sufficient to...
Probable cause?
Yeah, probable, yeah, exactly. And I think also when you look at it from the second sub-issue about the sufficiency of the preliminary hearing and the sufficiency of the evidence presented there, first off, as I cited on page 12 of my brief, I think that's an issue that is waived because it was never raised by the defense below. This is being presented for the first time on appeal, and I think this court's case law indicates that that is waived, if not challenged below. And the case law further indicates that even if you don't deem it waived, that an error at the preliminary hearing stages is going to be deemed harmless if there is sufficient evidence presented at the trial phase. And the defendant has not argued that at trial there was insufficient evidence to show that the defendant went to the residence with the intent to commit an aggravated assault against Bolden. And I cited specifically Butler on page 14 of my brief, where this court found that the trial court erred in admitting hearsay statements at the prelim, and this court concluded that absent those statements, there was not sufficient evidence to bind the defendant over. And yet, despite that finding, the court found that the error did not affect the subsequent proceedings and was therefore harmless because the state presented sufficient evidence of guilt at trial. So even if whichever route this court chooses to take, whether it's by saying that the challenge to the prelim is waived because it wasn't raised below, or whether it goes the route of saying that any error was harmless because there was clearly evidence presented at the trial phase to establish an aggravated assault as the underlying felony, then the defendant cannot prevail on either one of those theories. I think that along with the questions to counsel, I think that covers all of the arguments that I intended to make with respect to issue 1. I'd be happy to answer any questions about it, but I feel at this point the record is fairly clear on what exactly happened here, and I just wanted to emphasize, as Justice Johnson did, that this issue with respect to the aggravated assault against Miss Green is to some extent a red herring, because it just I can understand why it can appear a little bit confusing, but that is a separate crime in and of itself and does not directly affect the felony murder and aggravated burglary charges. I think that was really the only issue that counsel argued today, and it was the primary focus that I intended to have in my argument. So again, I would submit the remaining issues on the brief, but would be happy to answer any questions. Without any questions, if there are none, I would respectfully just request that the defendant's convictions be affirmed.
Do we have any questions of counsel? Thank you, counsel.
I would reference the court to volume 6 of the record at page 157, according to the facts of my brief. Ms. Bonner's counsel asked the court to clarify what aggravated assault was being used to support the felony murder, and the court found the aggravated assault against Ms. Green was the only aggravated assault that occurred, and that there could have been an intent for aggravated battery against Mr. Bolton. And that's at page 157. At page 153, the state, according to my facts, and please double check me, I'm not always perfect, but I do try to be in my fact referencing. At page 153, the state described the only aggravated assault for which there was evidence was that against Ms. Green. So if I'm correct in that the court expressly made a finding that the underlying aggravated assault was against Ms. Green, then the felony murder and the burglary are invalid.
So you've clarified you're not challenging the sufficiency of the evidence at the preliminary hearing.
No,
Your
Your Honor.
challenge is to the sufficiency of the complaint.
Yes, Your Honor.
And how is the complaint deficient?
In that
Specifically.
the state can only file a complaint on charges for which the defendant was bound over and based upon the evidence.
I understand the theory, but what about the complaint? What specifically in the complaint is either missing or is stated incorrectly?
Well, as it was altered by the state in the course of trial, they chose...
No, I'm not talking about trial. I want to know what about the complaint itself is defective.
Well, it's the application of the complaint at trial without amendment.
And the
The only
application
thing-
was in the argument, closing argument?
Pardon me, Your Honor?
Because this, you...
Well, the
state
jury
argu-
instructions
Okay.
and the court's...
So are you complaining about the jury instructions deviated from the complaint?
Yes. The problem is there
So
was
that's not a defective complaint, is it? I mean, the complaint charged the crime. Would
in
you
general
agree with
terms.
that?
Yes, Your Honor.
Okay. And so your complaint is that the jury instructions deviated from the complaint.
The district court never garnered jurisdiction because he wasn't bound over for a burglary based upon an assault against Ms. Green. He was never bound over for that crime. Therefore, he could not be convicted of those charges. He was bound over specifically on a burglary based upon an assault against Ms. Green.
So
not Mr. Bolton.
if the problem was he was never bound over, then you're challenging the preliminary hearing.
No, Your Honor.
Okay.
The court at the preliminary hearing made a valid finding based upon the evidence that was presented to it, which was only an aggravated assault against Ms. Green. That is sufficient. The problem is the state chose to proceed to trial against Mr. Brown based upon an aggravated assault against Mr. Bolden. The jury instructions, the conviction, the evidence presented, all premised upon a crime that he was not bound over for. It's not a fault with the preliminary hearing. If they had alleged and asserted that the aggravated burglary was based upon an aggravated assault against Mr. Bolden, no issue. None whatsoever. The state elected, the court found only an aggravated assault at preliminary hearing against Ms. Green. And the defendant has a right to know the charges against which he is defending. And he was told at the preliminary hearing, you are defending against an aggravated assault against Ms. Green as the premise for your burglary, which is then the premise for the first-degree murder. It was a bait and switch. And actually, I think more than anything else, it was just inadvertence. Generally, you don't have the specificity of a finding that you do in this preliminary hearing. It's kind of a unique situation because I agree with you, Justice Johnson. In most cases, the court says, I find by a preponderance of the evidence and I bind the defendant over. But in this case, it was a specific finding based on specific evidence and specifically chosen by the state. The fault here is not with the court, it's not with Mr. Brown, it is the state. As they have prosecutorial discretion about how they wish to proceed, they proceeded incorrectly. And by doing so, they deprived the district court jurisdiction to convict on either the aggravated burglary or the first-degree murder being premised against an aggravated assault against Ms. Green. It was laid out plainly. And that coincides with my argument and belief, we're not talking about really difficult stuff here. Is the state required to amend a complaint when the instructions or their theory of the case does not comport with the language of the complaint information? Can it just be narrowed by agreement? Going back to Justice Luker's point, I would say it's the opposite. Why bother having a requirement to amend the complaint to conform to the evidence if everybody can just do it without asking, without review of the court, without a finding by the court that it's appropriate? If the state is going to elect to specify and take little pieces out of a very broad complaint, then are they not required by statute to request an amendment to the complaint? And it's not that difficult to do, because we all know judges will grant it by statute. It's supposed to happen if there's no new charge. But they don't, and they haven't. And I see no questions, and I thank you all.
Do we have any questions of counsel? Thank you. Thank you both for your arguments this morning. Court will take this matter under advisement.